Hey, good afternoon, everybody. Welcome back. Excuse the starting late. I had a training on KV Core that went late. And so that's why I'm running a little bit behind schedule. So I want to make sure it's running on websites. So I want you all to give Facebook permission. Let Facebook know to give StreamYard permission to post your name, okay? And who it is that's coming around. Okay. Let me share my screen. So bear with me. I've got to set up all the all my PDFs, okay? So I just got home, so I'm rushing, so bear with me, please, okay? So in the moment, say hello, see who's here, and let me get the document that we always use. Table of contents, cover page, answers, state questions, acronyms. Okay, so far there's 5 of you here. So be patient, please, okay? While I get all this going. We'll start out with our usual. Oh, dang it. Something is not available. So what the heck is that? I don't want that one. So we'll get going in just a moment, okay? So let me open some other documents here. The glossary, state questions. So don't go leaving, okay? Reopen PDFs from last session. No, I don't want that one. That's a home warranty. So I'm rushing here, okay, because I didn't get home in time to start this. So I'm going to ask that you be a little patient here as I get prepared. Table of contents. Come on, click. Where's the cover page? All right, it's dwindling down. People are giving up. Impatient individuals, right? Just because a person is not ready completely. Okay, this is a source that we're using. And that's because it's an excellent source. Oh, gosh, what's going on here? Dang it, dang it, dang it. Well, I think I lost all of you. Okay, we're still on. I thought I had lost you. And we're actually still on. I ended up, so let me get the table of contents here. It didn't open up. Okay, so this is the source that we use. Again, this is an old source. I repeat every time that we start. So go ahead and say hello, okay, if you're on here, so that I know who's on here, because I lost the page that I was on. Gosh, I'm not usually this disorganized. Okay, so let me get the Facebook page going. And it's an old source, and it's excellent because it has 4 exams, okay, of 110 questions. As you can see here, 1, 2, 3, 4. It has 80 national questions, 30 state. It was created in 2006. However, it is still an excellent source for you to prepare for your exams. Several of my students that just passed recently said a lot of questions are very much like what's on the exam, which is a good thing, okay? And then it also has the real estate glossary that we use. Said a lot of questions are very much the glossary that we use, definitions or key terms, vocabulary. It has a refresher course, a math review, some ideas on how to prepare for the exam, and a general topic of sales exams. And the questions are explained. Hi, Tanya. ¿Cómo estás? I don't know if everybody on here speaks Spanish, but if not, I do Spanish and English. So any of you that are new on here and that haven't given Facebook permission for StreamYard to post on Facebook and show your name like Tanya, okay, then give Facebook, go to this link right there, StreamYard.com/Facebook, give permission to Facebook to show your name whenever you post on StreamYard, okay? So we're going to start off with glossary as we always do. And why is that? Because it's very important for you to learn the vocabulary. You're learning a new language. And I'm now broadcasting this to my personal Facebook page, to our group, and to YouTube. So this is recorded on Facebook and also on YouTube. So you can watch it on whichever media you like. Okay, and you can invite other people, okay, that want to attend it and they're not a part of our group because our group is private. And the only way they know about it is when I invite them through Trek. Okay, so today we're starting with legal description on page 169. So this book is 287 pages. Okay, and then we'll go into national questions and state questions. We'll take a little break in between. Muy bien, gracias. Awesome. Que bien, Tanya. Hey, I want you to come over here. I just went through an awesome training class for our CRM, Contact Resource Management software that, oh my gosh, we can post to all types of social media, create a lot of things. It is a techie, smart software that we use to have all our contacts and create lots of leads for free. You can pay for some, however, you can get free leads. Okay, so enough introduction. And so I am Wild Lillie Handy. That's my new name, Wild Lillie Handy. That goes back for like 30 years ago when I was an engineer and in college. So legal description. Okay, so if you see here, let me see here. That one is, let me undo that. You see on the subject here, it shows Wild Lillie Handy. Okay. See there? That's what I'm going by. And I'm a little wild. I get loud and I get all excited and I laugh and I like to help people, motivate you, inspire you, all of the above. And I'm now hustling to get a whole bunch of listings, 25 listings in 3 months. And this started last Friday. I've got 3 already. So I'm knocking on doors. I'm calling for sell by owners. I'm going to be cold calling. So anything that I'm doing, I'm going to be teaching you, I'm going to be doing. And that's for when you become a realtor and you become my partner at EXP. Okay, legal description. A description of a parcel of real estate, specific and complete enough for an independent surveyor to locate and identify it. So all the documentation on how properties are identified with the county, with the title company, on the deed, on the listings, they all have the legal description because that identifies the exact property. The addresses could be wrong, so it doesn't go just by the address. It has to have the legal description. If you see my face looking in a different direction, it's because I've got 2 screens, one on the right, one on the left, and the camera is right in front of me. So that legal description is very important, and it goes on sales contracts, on listing agreements, anything that we do as far as legal documents. Lessee, lessor, the OR and the EE, right? EE receive, the OR is a giver. So let's see, the one who receives the right to use and occupy property during the term of the leasehold estate, right? They're renting it. So it's called the leasehold. They're holding a lease. Oh, you know what? There were a couple other students that wanted to join and I meant to admit them. So bear with me. I was going to do it before class and I was driving and not a good thing to do. Okay. So let me take a screenshot and admit them. So they can participate in the class if they want. Okay, it was only 2 of them. Okay, we're up to 629 members on our private group. All right, so the lessee is the tenant. The lessor is the owner of the property, is the landlord, right? And the landlord owns the property, but the tenant the lessee has possession of the property, okay? Leverage. The use of borrowed funds to purchase an asset. So we use leverage. We borrow other people's money or we go to the bank and we get a loan in order to buy property, right? So that is the way we use to buy investment property, homeowner property, land, any type of property. So leverage. So that is considered leverage. Now, once you become a realtor, if you don't want to do all the work, you can leverage people. You can assign the work to other individuals and you focus on what you're best at. Levy, to assess or collect a tax. Okay, so when a neighborhood can be assessed for a sidewalk or at a subdivision, and then you may end up having to pay additional taxes. License, that's what we're working on getting here, right? So a revocable authorization to perform a particular act on another's property. So we're representing somebody else and getting paid. So 2, authorization granted by a state to act as a real estate broker or salesperson. So we start out as a salesperson, right? An agent, a realtor. When you pay all the fees, the local board, the Texas Association of Realtors and the National Association of Realtors, now we are called a realtor. We have more credibility. Lien, A legal claim against the property to secure payment of a financial obligation. So whenever we have a loan and we borrow money, right, we use leverage in order to purchase a piece of land. That lender is going to put a lien on the property. The property is the collateral, and that's going to show on the warranty deed and the deed of trust. It's a legal claim. Life estate, for the life of somebody, okay? A freehold estate in real property limited in duration to the lifetime of the holder of the life estate or another specified person. So it doesn't have to be the spouse. It doesn't have to be a relative. They can provide a life estate to anybody that they wish. Once that person passes away, it goes back to the original owner. What it's called, it reverts back, or it goes to the remainder person, to a third party that the original owner assigned to. Life tenant, one who holds a life estate. So this tenant up here, we call them a tenant, right? Because they have temporary use of that property until they pass away. They are a life tenant. They're there for their life. Liquidity, anything that you can easily convert to cash, okay? A home is not easily liquidated, right? Oh, well, nowadays they can sell in 15 days, 5 days, you know, get an offer in 1 day. But it's the ability to convert an asset into cash. You might have CDs. CDs have a time period. It could be a 6-month CD, a 12-month, 2-year. You cannot liquidate that quickly. Your stocks, okay, you can liquidate stocks. You put in an order to sell, you liquidate it, you get the cash. A piece of real estate might take a little bit longer to liquidate. However, it can be done. It just takes longer. Lis pendens, a Latin phrase meaning suit pending. A public notice that a lawsuit has been filed that may affect the title to a particular piece of property. Listing agreement, a contract between the owner and a licensed real estate broker, where the broker is employed to sell real estate on the owner's terms within a given time, for which service the owner agrees to pay the broker an agreed upon fee. So we don't actually sell it. The owner is selling it. We represent the seller to market the property to generate a ready, willing, and able buyer, right? And that can be brought to us. It can be procured by any other realtor or ourselves, or a person that just comes, you know, to the property. So that's a listing agreement, has a start date and an end date, and specifies the price and what the terms are, the commission that's paid on it, okay? And if there's any fees owed to the, aside from the commission, what the terms are, the commission. So I've got all these different electronics going. Listing broker. So who do the listings belong to? The broker, right? Even though the one who ends up signing it is the associate for the broker, which is the realtor or the agent. We're the ones that deal with the client, okay, and take the listing. However, they belong to the broker. Should you end up leaving that brokerage and you acquired that listing, it didn't come to you from the company, then those listings go with you. There's some brokers that are sticklers. However, you brought about those listings. Those are your clients with your marketing and advertising. If a listing broker is providing a lot of the marketing, they're paying for generating the leads, then they may not want you to take it with you, because they're saying, no, we did all the work. All you did was go deal with the client and list the documentation. So whenever you're interviewing companies, make sure you ask, should I have our listings, do they belong to you, but I brought them, or they mine, should I leave? If they say no, walk away, go to another broker, come to EXP. Okay, littoral rights, littoral lakes, riparian rivers. Okay, so landowner claims to use water in large navigable lakes and oceans adjacent to property ownership, rights to land bordering bodies of water up to the high water mark. So you can navigate on these lakes, okay? They're just not running water like a river or a creek. A loan, a sum of borrowed money, a principal that is generally repaid with interest. Most loans are principal and interest, PI, and others are considered ARMs, adjustable rate mortgages. Those might be interest only, right? And they're only good for, 1, 3, 5. It's usually a negative number, except when it gets to 10, 1, 3, 5, 7, 9, or 10 years. And at that time, it changes. The interest rate could change. Those could be interest only. Most loans are principal and interest on borrowed money. Right now, interest rates are, in the 2s and 3s. Loan officer or lender serves several functions and has various responsibilities, such as soliciting loans. A loan officer both represents the lending institution and represents the borrower to the lending institution. So there are loan officers that work at a bank, and then there's mortgage brokers. Those brokers are like an insurance broker or a trucking company broker. They deal with a lot of different providers. So a mortgage broker deals with a lot of different lenders, a lot of different banks. When there's a loan officer that works for a bank, they only have loans from that particular bank, okay? So a lot of times it's good to go with a mortgage broker that's going to have loans available to meet the needs of a particular buyer or investor. Lock in, an agreement in which the lender guarantees a specified interest rate for a certain amount of time. So once the buyer is approved and they have a home, the lender will lock the rate, especially if it's really low, because loan pre-approvals, okay, can have a 30 or 60 or 90 day, and the interest rate can change, right? They can be good only for 30 days or good for 90 days. After that, the interest rate's going to change. So before the 90 days are up, you're going to want to lock it in if you have an interest rate like 2%, right? So that is the lock-in amount. Lock-in period, the time period which the lender has guaranteed an interest rate to a borrower, 30, 60, or 90 days. Lot and block description, a method of describing a particular property by referring to a lot and block number, which a subdivision recorded in the public records. So a subdivision, right, has a lot of little lots, and each lot has a home on it. So that's one particular block. And within that block, okay, within that square, I have to see how my camera is, okay, you'll have a lot of little ones, okay? So the big one will be the block, and then all the little ones are the lots. And there's a house on each lot. So the legal description, okay, if it has a lot and block, is going to include that. Management. So we're starting the M's. Management agreement, a contract between the owner of an income property and a firm or individual who agrees to manage the property. So property management agreement, right? So those, in order to do property management, you must have a broker license. In order to become a broker, you have to do real estate for 4 years and meet so many different requirements. You don't just become a broker because you practice real estate for 4 years and you apply. Have to sell so many residential, land, commercial, multiplex. So it's different types of properties that have to be sold, representing sellers, representing buyers, representing tenants. So that is a more experienced individual that is going to be allowed to become a broker when they take the broker exam. Margin, the difference between the interest rate and the index on an adjustable rate mortgage, okay? The difference between the interest rate and the national index, right? On an adjustable rate mortgage, which is ARM, A-R-M, that's the acronym. The margin remains stable over the life of the loan, which while the index fluctuates. So that's why when it's locked in, if the index fluctuates, the interest rate will not. Market data approach. That's traditionally the type of CMA that we typically do, right? Comparable market analysis. So it is a method of estimating the value of a property by comparing it to similar properties recently sold within the last 3 to 6 months, typically 6 months, right? When a market is moving really fast, it could be 2 to 3 months, okay? Something that sold 6 months ago might already be considered old if the market is, properties are turning around every 30 days or less. So it's the amount that a seller may expect, market approach. So it's for a method of estimating the value of a property by comparing it to similar properties recently sold within the last 6 months is traditionally, and making monetary adjustments for the differences between the subject property and the comparable property. Market value. So in market data approach, they have to have similar square footage, plus or minus 300 square feet, and similar year, plus or minus 5 years. Similar bathrooms, bath 3, 2, and the square footage, if they have the same square footage but don't have the same number of bathrooms, bedrooms, it could have an office, okay? So it still has that kind of room that could be converted. And similar property size, land size. The market value, the amount that a seller may expect to obtain for merchandise, services, or securities in the open market. So we do a market value using the market data approach for a seller. We also do one for the buyer before we recommend a price for them to offer, or when they start saying, I'm going to lowball it, right? I say, well, based on this market data, the market value of the market data approach states that more than likely they won't. But we never know what a seller is going to accept. However, being, extremely ridiculous and lowballing, seller would have to be in a desperate situation. Marketable title. Title of property that is free from encumbrances, right? Anything that's attached to it, and reasonable doubt, and that a court would compel a buyer to accept. So encumbrances, anything that could be encroaching, liens, anything that's attached that creates a problem, creates a cloud on title. It has to be free of all those. Mechanics lien. So it's not necessarily an auto mechanic, but it's a mechanics lien that contractors can put on a property if the owners don't pay them for the construction work or the repairs or remodeling. So it's a statutory lien created to secure payment for those who supply labor or materials for the construction of an improvement to land. And that improvement can be home improvement, making improvements to the land, putting in a well, a septic, a fence, whatever type of improvement to that land, okay? That increases the value of the price, and they have to be paid. There is a limit, okay, that they have to abide by and present a document letting the seller know or the owner know that should they not pay, they're going to file this in the court and create a lien on the property. So statute of limitations, okay? Meets and bounds. Where do things meet? What are the boundaries? Okay, a method of describing a parcel of land using direction and distance. Okay, so they might say, okay, we're going to go 90 degrees from the street, 90 degrees north, and then we're going to turn 90 degrees east, and then 90 degrees south, and then 90 degrees west. So that creates a perfect rectangle or square, right? It ends up where it started. The end point is the same as the start point. Excuse me for that. Forgot to put my phone on mute. All right, mill, 1/10 of 1 cent. 1/10 of 1 cent. Used by some states to express or calculate property tax rate. So 1/10. So if you have 100 cents, 1/10 will be 10 cents, right? So minor, a person who has not attained the legal age of majority. So a minor can still buy property. However, they have the right to void that contract, right? Doesn't mean that it's illegal. It just means they have the right to do that. Minors could be wealthy and very brilliant and able to buy property. Okay, but they have the right to be able to terminate it. Misrepresentation, a misstatement of fact, either deliberate or unintentional. If we're providing false advertising, okay, that's deliberate with an intent to create malice. But there is certain misrepresentation, even though it was done unintentional, there are things that we are supposed to know and not do. Modification, the act of changing any of the terms of the mortgage. So right now, during COVID last year, many individuals requested a forbearance. So it was modified so that they didn't have to pay or could pay a lesser amount for a certain month. All those payments that they missed are being added at the end of the loan. So the loan amount has increased by all the interest that they didn't pay. Even if they paid the principal, they still have to pay the interest. So now they're going to be paying interest on interest. However, it may have saved their home. But it's going to cost them more to purchase that property because of the modification during COVID. So more than likely, we're going to end up having lots of foreclosures. Money judgment, a court order to settle a claim with a monetary payment rather than specific performance. A spousal support judgment, child support judgment, rental landlord judgment, okay, things like that. Month-to-month tenancy. So periodic tenancy can be month-to-month, week-to-week, day-to-day, year-to-year. Tenancy in which the tenant rents for only 1 month at a time. So that's what month-to-month tenancy is. If it was week-to-week, like at hotels, they're renting for a week at a time. And it renews as long as they stay there and they're paying. Monument, a fixed visible marker used to establish boundaries for a survey. Okay, so if you have a corner piece and that consider that a marker, then that is a visible spot that they can determine as a marker. They'll put a marker stick on it, or they'll put a metal stake to mark that corner, and it's fixed. A metal stake will be a permanent fixture, and they can then use a metal detector in the future. A lot of times nowadays they don't do that. They use just wooden sticks on the surface, and that's not going to permanently mark them. Mortgage, a written instrument that pledges property to secure payment of a debt obligation as evidenced by a promissory note. Now, a promissory note is not recorded, okay? Remember that. The warranty deed and the mortgage or the deed of trust, okay? Mortgage, deed of trust, pretty much equal. It just has a different type of foreclosure method. But the warranty deed is recorded and the deed of trust is recorded and the mortgage. It's a written instrument. It's a document that pledges property. So the property that's pledged is considered the collateral to the lender for the lien that they're going to put on that property to secure their payment, right? Of a debt obligation as evidenced by the promissory note. When duly recorded in the public records, a mortgage. So the mortgage is the one that's recorded, not the promissory note. A mortgage creates a lien against the title to a property. So the warranty deed will say the warranty deed with vendor's lien. So if there is a loan on it or a private owner, seller finance, it'll have a vendor's lien written on the warranty deed. And then there will be the deed of trust, which explains the steps of what to do when someone defaults on making the monthly payments, defaults on the mortgage. A mortgage banker versus a mortgage broker. So a mortgage banker, an entity that originates funds and services loans to be sold into the secondary money market. The mortgage broker is an entity that for a fee brings borrowers together with lenders. So a mortgage broker will have multiple lenders that they work with. Mortgage banker, it's a bank. They have their own loans. A mortgage lien, an encumbrance created by recording the mortgage or deed of trust. And that's recorded, okay, in addition to the warranty deed. Mortgagee. So who is the mortgagee? Is it the borrower or is it the lender? Okay, it is the lender who benefits from the mortgage. They are receiving monthly payments, okay, from the mortgagor, which is the borrower. So the lender receives the collateral, okay, from the borrower. If it's a deed of trust, the trustee receives the warranty deed because it has a vendor's lien on it. So the trustee holds on to the warranty deed, and the beneficiary is the lender. So on a mortgage, okay, or deed of trust, in Texas, we have deed of trust. In other states, there's a mortgage. So on the deed of trust, there are three members: the trustor, the trustee, and the beneficiary. The trustor is the mortgagor, the borrower. The trustee is the person that holds the warranty deed and follows the instructions of the deed of trust when the borrower is in default and they have to file a foreclosure. So instead of the lender doing it for the bank, the trustee does it. But the lender is the one that benefits. That's why they're the beneficiary. So the EE, in this case, they receive, right? And you would think, well, why is the lender receiving? Well, they're receiving the lien that is they're receiving the trust, the deed of trust, okay, that is protecting them in the case that a borrower defaults. So they are also receiving monthly payments. Mortgagor is the giver, is the borrower. Okay, they're making payments to the lender. Multi-dwelling units. Multi-dwelling units. Properties that provide separate housing units for more than one family and secure only a single mortgage. Apartment buildings are also considered multi-dwelling units. Now, if we have 4 dwellings, okay, 4 dwellings is still residential. So that's a fourplex, okay, a quad, or a duplex, 2, or a triplex. If it goes above 4, then it becomes commercial property. Multiple listing service. That's where we will list all the properties for sellers we represent, and then also look for properties for buyers that are looking to buy or for tenants that are looking to rent. The method of marketing a property listing to all participants in the MLS. Mutual rescission, an agreement by all parties of a contract to release one another from the obligations of the contract. Okay, we're now at about 6:45. We're going to end with vocabulary there now. So take a moment break while I write this down and get myself something else to drink. And then we will start with national questions. So next week, we will start with negative amortization on page 170. Okay, I need to take a moment and get something to drink so you can interact. Hey, Curtis, how you doing? The or for the party who pays and the fee for the party who receives payment. Yes, except for when it comes to the mortgagee. The mortgagee is the bank is the receiver, right? Okay, they receive, you're right. However, some people think that the mortgagee, which is the lender, they're the ones giving, right? Because they're giving the money to buy the house. But yes, so you have to remember, as Curtis put it on there, OR, the giver, EE, the receiver. Okay, kitties, hold on, let me feed you. I gotta feed my kitty cats. Sorry. There you go. All right, kiddos. Okay, we're back. Okay, so now we're going to do national questions on the Kindle. Oh, that's a book I recently bought, and it is awesome to manifest whatever you want pretty much in your life. Okay, so this is the book that we're going to use when it comes to, okay, let's see. No, I'm going to go to page 136. Yes. Okay. So let me show you the source. So this is a 2020 book that I bought in December. And I like this because, again, it has multiple exams. It reviews the material. It goes through the national review, the state review, all the different categories, okay, that you have to learn. Real estate math, Texas law and regulations, national practice tests, Texas state level practice test, and then it has a Texas license examination sample question and the answer key. Okay, and so then on national, we are on question 2.9. So we're dealing with test 2 encumbrances on page 136. Okay, let me close this. So we're on question 2.9. Okay, there we go. And let me. Okay, so we can see the whole thing there. Hopefully you can see it on your on your phone large enough? If you don't, let me know. Let me look at it on my phone. And it looks a decent size. Sometimes I'm able to do it bigger. Okay, so these are national questions. Let me type on here that we're on national questions now. So Curtis says, you're doing good. I guess it's just 2 of us on Facebook Live. Yeah, it's right. It keeps changing from 2 to 5 people. So going in and out, I'm the one on YouTube, and yeah, there are 2 of you, I think, on Facebook. Well, right now I can only see 1 of you. However, there are 2 individuals watching. Okay. In a lien theory state, what kind of interest does a mortgage lender have in the lien property? In a lien theory state, what kind of interest does a mortgage lender have in the lien property? A, possessory interest. B, a tenancy by mortgagee interest. C, a legal interest in a pro rata share of the property. Or D, an equitable interest. Oh, you know what? I may be the other person besides you that's watching. I think Tanya left. So a possessory interest, a tenancy by mortgage interest, a legal interest in a pro rata share of the property, or an equitable interest. So the lender has what kind of interest on the lien? So right now we're on national questions. Okay, so Curtis, what do you think? So the lender, owns the property, but they don't have all the bundle of rights, right? Because they are the ones that loan the money, and they hold the warranty deed in addition to the borrower. So the answer here is 2.9D. Very good, Curtis. 2.9D. So your studying's going good? You're still going to the library? Number 10, how is a lien terminated? Okay, the lien is the mortgage, right? Payment of the debt that is the subject of the lien and recording of this satisfaction. B, transfer of the property that has the lien. C, recording of another lien that is superior. Or D, death of the lienor or lienee. That's great. You come every day. That's awesome. Okay, so 2.10, how is a lien terminated? By payment of the debt that is subject to the lien and recording of the satisfaction, which is what is recorded is a release of liens. So Okay, so Lindsay, I'm waiting for an answer. Nobody taking the risk? Okay, the answer here is A. Okay, it is when the lien, the payment of the debt that is subject of the lien and recorded as of the satisfaction. So the borrower receives a release of liens and that is recorded. So you're just about to finish your principles course. I am at that on the last unit until unit 12, then to take the course exam. All right. So do you have to take a second course? All right, so Curtis also said 210A. Very good. Okay, number 11. A judge rules in favor of the creditor in a court proceeding and places a judgment lien against all the debtor's assets, including their real property. This is an example of what kind of a lien? A, voluntary junior lien. B, involuntary superior lien. C, involuntary specific lien. Or D, involuntary general lien. Okay, so keep in mind here, it says a judge rules in favor of the creditor in a court proceeding and places a judgment lien against all of the debtor's assets, including their real property. So think about that. Is that specific to one or is it a whole bunch? This is an example of what type of a lien. Hi, Gloria. Gloria says D. Thanks for joining us, Gloria. Gloria Lujan is watching on YouTube. Awesome. Remember to like the video, please, and also on Facebook. Okay, so Gloria says D. How about you, Curtis? There are 4 of you watching, so it's a good thing to participate on these questions because if you, for some reason, get it wrong, I will help clarify it. So 2.11, I'm getting ready to give the answer. Okay, one more moment. I'm typing on both YouTube and Facebook. Anybody else? I just found you. I'm taking my exam next Monday. So excited and nervous. All right, Gloria. That's awesome that you found me. Where are you located, Gloria? It's normal to be nervous, and especially coming on Monday. I wish I was doing it Saturday, but I'm going down south to the Rio Grande Valley to do a listing, so I'm not going to be available Saturday morning. So I'll put a prayer in for you. So let's see. Curtis said, oh, El Paso, Texas, El Chuco. I used to live there back in 1982 to 1989, 7 years. Okay, yes, unfortunately, I'm needing, let's see, Curtis is saying, unfortunately, I'm needing 60 credit hours total before I can retest, which principles, oh yeah, so that's 2 courses, 30 for state and 30 for national, got it. So number 211, let's see, Curtis says D. And Gloria Lujan is from El Paso. Way to go. Yes, the answer, I'll give you a chance to answer, Gloria. Oh, you already did. You said D. Yes, the answer is D. 21D. Very good, both of you. It's an involuntary general lien, right? When it covers all the debtor's assets. Okay, number 212. It doesn't all show on one page. So let's see if I make it a little smaller, if it'll show. Let's see, which is it? Number 212. Dang it. I have to keep moving around to see. Okay, there we go. Now we get to see all of 12. 12, a real estate tax lien. Tax lien, okay? A federal income tax lien, a judgment lien, and a mortgage lien are recorded against a property. Which lien will be paid first when the property is sold? A, real estate tax lien, B, federal income tax lien, C, a judgment lien, or D, mortgage lien. So which one has priority? So Gloria, is that your first time taking the exams? So again, a real estate tax lien, a federal income tax lien, a judgment lien, and a mortgage are recorded against a property. Which lien will be paid first when the property is sold? Oh, darn it. Okay. Yes, first time. All right. It's okay to be nervous. You know, the good thing about taking the exam the first time, if for some reason you were not to pass, you get an idea of what the exam is like and what you need to focus more on to study, what sections. However, you might pass on the first time. And so when you affirm, I pass every single day, focus it. Remember, I showed you this book. Okay, this book is really good for that. Creative visualization. Use the power of your imagination to create what you want in your life. I bought that 20 years ago, gosh, almost 30 years ago, and I just bought it again because I want to practice that more. Okay, now can I easily go back where I was? Probably shouldn't. Yes. Okay. So which one is the answer? Which one has priority? Okay. Curtis says D. I would rethink that, Curtis. Remember, we can lose our property because we don't pay something else besides the mortgage. Well, hate to tell you. However, the answer is A. The lien that has priority is real estate tax lien. Okay, that's property taxes. That has priority over anything else. The local city or county, the county is going to get the real estate taxes paid first. And then the next one is the mortgage lien. So the answer is 212A. Okay, not the judgment lien. The judgment lien is one of the last ones. If there's any money left over, they might get something. So the answer is 212A, real estate tax lien. Remember that property taxes, that's real estate tax lien, always has priority. That is an always. Even in a foreclosure, they get paid first. Number 13, A lien holder can change the lien priority of a junior lien. That's like a second lien, right? The first lien is priority, and another one is a junior lien, by agreeing to do what? So a lien holder can change the lien priority of a junior lien by agreeing to do what? A, change the date of recording. B, lower the amount of the claim. C, cancel the lien. Or D, subordinate the lien. A lien holder can change the priority of a junior lien, can change the lien priority of a junior lien by agreeing to do what? My kitty cats are doing something crazy, making noise in the background. I had to take a break to also feed them. Okay, so on 213, change the date, lower the amount of the claim, cancel the lien, or subordinate the lien. Let's see. Gloria says B. Lower the amount of the claim. No. Lien holders are not going to voluntarily lower it. There has to be negotiation, okay, from the one wanting it lowered. And only if there's an agreement will they do it. But not in this case. There's a lien holder can change the lien priority of a junior lien by agreeing. So let's say they are a higher lien position. They can become a subordinated lien, a lower position lien, which means the first lien gets paid first, and then any junior liens get paid second, third, fourth, whatever position. However, if they do the foreclosure because they haven't been paid, that means there's a borrower that had more than one mortgage, and the first mortgage is always the largest unless they end up paying a lot down and then they get an equity loan. That becomes a junior lien. That's a lien, a loan on the amount of equity that they have on the property. That's what they've paid down on it. But it's a junior lien, so they can subordinate that lien and become a lower position. Okay, so that is 2113D. Subordinate the lien. They can still go into a lower position. Oh, so I didn't show 212, or I did. 212 was A. 213 is D. Okay, number 14. Can you all see it large enough on your phone? Because many individuals do it on their phone. Hi, Ana Denise Juarez. Oh, you just joined recently. Okay, so number 14. Which of the following accurately describes the act of foreclosure? And when does a foreclosure happen? When somebody is default on their payments, right? They're behind on their payments. A court-ordered acceleration of loan payments. B, the final step in a bankruptcy filing. C, a proceeding to enforce a lien by forcing the sale or transfer of a secured property. D, a proceeding to take equitable title to a property that was liened as security for a mortgage loan. So which of the following accurately describes the act of a foreclosure? So accurately describes the act of doing a foreclosure. There's two different types of foreclosures. Judicial foreclosure, which is done by a judge. Those are the ones that have a mortgage, or a non-judicial for properties that have a deed of trust type of mortgage. They don't need to go to court. The deed of trust already has instructions on how to proceed with the foreclosure. So anybody, a court order acceleration of loan payments, the final step in a bankruptcy filing, a proceeding to enforce a lien by forcing the sale or transfer of a secured property, or D, a proceeding to take equitable title to a property that was liened as security for a mortgage loan. So remember, a foreclosure is forcing a sale, okay? Come on, take a risk. Give me an answer. Okay, Curtis says C. Oh, that's interesting. Anna doesn't show up on my computer, yet she shows up on my phone. And I think she's on Facebook. So I wonder why she doesn't show up. Okay, Curtis says C. Yes, the answer is C. A proceeding to enforce a lien by forcing the sale or transferring of a secured property. Right? The property is secured by collateral. And the collateral is the home. Boy, I was almost typing the wrong answer. 214C is the correct answer. Okay, number 15. A property is secured by a mortgage that does not contain a power of sale clause. To foreclose, the lien holder will have to do what? A, file a deficiency suit. B, file a foreclosure suit. C, file a suit to quiet title. Or D, obtain a quitclaim deed. So a mortgage that does not contain a power of sale clause. So does the lender file a deficiency suit? That means there wasn't enough money to pay off the loan and they have to pay additional later. File a foreclosure suit. C, file a suit to quiet title. You know, the lien does put a cloud on the title. However, the lender is the one that's going to be foreclosing. So they don't need to quiet title, right? D, obtain a quitclaim deed. That's the last type, the least warranty deed available out there. And that's not going to benefit them. That's not the proper way to take over a property when there are liens involved. So it leaves us with A or B. Okay, Curtis says A. Not necessarily. So a property is secured by a mortgage that does not contain a power of sale clause. To foreclose, the lien holder will have to file a foreclosure suit. B. So they're going to go to the court and get a lawsuit, okay, approved by the judge to foreclose. So 215B is the correct answer. The only way there's going to be a deficiency is if first the property is foreclosed and there's not enough money from the sale of the property to pay off the loan, then there's still going to be a balance owed. That is the deficiency. And therefore the lender will file a deficiency and that borrower has to pay the remaining balance. Enjoying this learning live feed. Hey, Julia, how's it going? My friend, my Alamo Heights friend. Okay, number 16. So thank you for participating, all of you. So, oh, I was stuck on either A or B, says Curtis. Yes, you know. So foreclosure means the lender has taken steps through the court to foreclose on that property. So it's a mortgage and not a deed of trust. Okay, number 16. A homeowner defaults on his or her mortgage loan. In the subsequent foreclosure action, the lender takes title to the lien property directly instead of initiating a court-ordered public sale. So this is an example of what? So what kind of a foreclosure is it? A, strict foreclosure, B, judicial foreclosure, C, non-judicial foreclosure, or a D, deed in lieu of foreclosure. So what does it say? The homeowner defaults. Okay, so they're in default of their mortgage or deed of trust. So in the subsequent foreclosure action, the lender can take different actions depending on what the borrower might ask for. So the lender takes title to the lien property directly. So the borrower decided to return the property back to the lender instead of initiating a court-ordered public sale. So instead of having a foreclosure, the borrower said, hey, lender, I'm going to voluntarily return the property back to you because I'm not going to be able to keep it. So there's a name for that. So they don't want a traditional foreclosure. So they return the property. When they're returning the property, they're conveying the deed back, okay, to the lender. So what does that mean? Strict foreclosure, judicial foreclosure, non-judicial foreclosure, or a deed in lieu of foreclosure. Okay, anybody taking a chance? Okay, Gloria says C, non-judicial foreclosure. And not exactly. So give it another chance, another try. Okay. Deed in lieu of foreclosure. That was probably the decision that I would have made initially. However, because they're avoiding it, but this is because of a court-ordered public sale. So that was a mortgage instead of a deed of trust. So in this case, it's a strict foreclosure. A strict foreclosure is a court proceeding that gives the lender title directly by court order instead of giving cash proceeds from a public sale. On default, the lender gives the borrower official notice. After a prescribed period, the lender files suit in court, whereupon the court establishes the period within which the defaulting party must repay the amounts owed. If the defaulter does not pay the funds, the court orders transfer of full legal title to the lender. So this is court ordered. Sometimes it could be a pre-foreclosure property and the borrower decides to do a deed in lieu of foreclosure. That option is in a deed of trust type of loan. it says on there they can do a deed of trust. So they return the property back to the lender, they convey the deed to the lender, and that's in lieu of doing a foreclosure. But in this case, it says the lender takes title to the lien directly instead of initiating a court-ordered public sale. So they went to the court to get a judgment from the courts, okay, to take the title back instead of doing a public sale, selling it in the court steps as a foreclosure property. So after a prescribed period, the lender files suit in court. Okay, so that's why it's a court-ordered public sale, whereupon the court establishes a period within which a defaulting party must repay. So they might give them, 30, 60, 90 days, a period of redemption. If the defaulter does not pay the funds, the court orders transfer of full legal title to the lender. So that's considered a strict sale, strict foreclosure, 216A. Oh, I put down 216D. Sorry. Wrong. Put user in timeout. That's funny. That's the wrong answer. Can I edit it? Wrong answer. Sorry, guys. I typed the wrong answer in there. It's 216A. See, in one spot I typed 216A, and the other one I typed 216D, but I can't remove it on here. On Facebook, I can edit it, but not on YouTube. So for those of you watching on YouTube, the answer is actually A, strict foreclosure, not D, okay? A. Okay, number 17, that'll be the last question for today on national. A property owner gives Deanna permission to cross his property as a shortcut to her kindergarten school bus. One day the property owner dies. Man, things change when somebody dies, unless, what right was Deanna granted originally, and will it survive the owner's death? A personal easement in gross, which continues after the owner's death. B, an easement by prescription, which continues after the owner's death. A license, which continues after the owner's death. Or a license which terminates upon the owner's death. Okay, so it's some type of an easement, right? Because the property owner gave Deanna permission to cross their property as a shortcut to her kindergarten school bus. So there was some type of permission, right? Some type of easement that was given. But what kind was it? So it said one day the property owner dies. What right was Deanna granted originally, and will it survive the owner's death? These are some challenging questions, y'all. Where's my mouse here? So on here, you would need to know the definitions, right? The vocabulary. A personal easement in gross, what does that mean? An easement by prescription. Okay, by prescription is for utility companies. An easement in gross. Okay, hold on. I want to make sure I'm not getting this wrong. So let's go to Google. Not there. See, where's my Google page? I have a Google page over there. No. Let me create one. Facebook. No. Okay, so when in doubt, we Google it, right? So what is easement in gross versus what were the answers? Easement in gross versus easement by prescription. Dang it. I've got all these darn screens and I'm like, which one is it? Well, easement in gross versus easement in prescription. Okay, so what's the difference? So what is an easement? What is the difference between an easement in gross and easement pertinent? So an easement in gross is an easement that attaches to a particular right to an individual, right? So you would think that because of the young lady being given permission, but if it's not recorded, it's not an easement, okay? The other one, and that is an easement given to an individual. The other one, easement and gross are recorded in the public record and are part of your property's title. If you benefit from an easement, such as a driveway over your neighbor's land, that easement is pertinent. You own the dominant tenement, and the owner of the property is the servient. So an easement in gross, excuse me, got something in my eye here. See, an easement in gross is a right allowing an individual to legally use a property owned by someone else. And the easement in prescription, why am I losing this? Easement in prescription. An example of prescription easement would be property owner using a part of his neighbor's property to travel across as a means accessing perhaps a side road that isn't in front of owner's house. The neighbor notices it, but never stops. So it becomes a walkway for them to alternatively exit the property. They can then end up taking over the property, okay, by easement or prescription and going to court and say, hey, I've been using this easement for a long time. And the owner knew it, but never did anything to stop me. So they can do a hostile takeover. And that is through adverse possession of that piece of property or easement. And the owner could lose it. But the other one, easement in gross, an individual had a right to go through it and use it at any time. However, that owner dies. So that easement in gross is no longer valid. So it leaves us with the license continues after the owner's death. Well, not really. That owner died. That person who died is the one that gave them that. So it leaves us with D, a license which terminates upon the owner's death. Okay, so the answer, let's see. Oh, hi, Beth. How are you doing? So 217 is D. A license which terminates upon the owner's death. A license is a personal right that a property owner grants to another to use the property for a specific purpose, to reach a kindergarten school bus. Unlike a personal easement in gross, which terminates only on the death of the grantee, okay, that's the one receiving the right to use the easement. A license is revocable at any moment. It is not transferable and does not attach to the land. It ceases on the death of either party or on the sale of the property. So that's why the owner gave the young lady, okay, the right to cross his property in order to go to the kindergarten school bus. However, he dies, so it ends. So that license terminates upon the owner's death. 217D. My Beth Bitala was a student of mine long ago, and she's practicing real estate in Corpus Christi. And I'm going to eventually show her the value of being with EXP, especially after what I learned today about our contact resource management and the benefit that we get from it and how to generate leads. Okay, number 18. Oh, what time? It's time to go into state questions. Okay, so that's the end of our national questions. So let me write this down. We will start with 218 on page 138. Number 2.18. Okay, let me bookmark that. And we're going to go back to our old source. On the PDF, go to state questions, and that's going to be on page 87. Okay, so we're done with national questions. Any, oh, that doesn't seem right. Oh, page 43. Any questions on national? We're going to start with question number 87. We're going over this source again because we ran out of state questions from the other books, and the third book, I don't like it. So I've got to buy a new one. Okie dokie. And I'm going to move the answers screen to another page, to another monitor. And that's going to be on page 43. You know, I got to have my answers to make sure I give you the right answers. And I did buy the book for champions. I cannot share that with you. However, it allows me to show you certain documents in case when we need them. Okay, so now we're going into state questions. So the last answer on national was 217D. So hold on here. Let me minimize this here, okay, so that I can still see who's replying. Okay, so we're going to do state questions now. And the state questions are in the Texas Real Estate Sales Exam, 4th edition, okay? All right, number 87. And continue participating. Write down the question, number, and the answer. Number 87. For the document to be eligible for recording at the county courthouse, the document must be what? So after a closing or whatever kind of document, it's going to be recorded at the courthouse. For it to be eligible to do that, it must meet what requirements? A, drafted by a Texas licensed attorney. B, witnessed by 2 persons with legal capacity. C, in English and acknowledged in the presence of a public official. Or D, in any language as long as it is witnessed by 2 lawful citizens and is notarized. Notarized. So we're in the United States. What's the primary language? Okay, so take time to think about this and write down your answer or type your answer. I met some even techier persons than me today. You know, there's always somebody that knows how to do it better or that can't do it as well. 87C. is one person. That's Gloria. So in English, and acknowledged in the presence of public official. Because when you go to the courthouse, the circuit courthouse, right, to record something, are you doing it yourself or is somebody else there? So the correct answer is C, 87C. The Public Recording Act requires that instruments must be in English and acknowledged by the presence of a notary, a judge, or the clerk at the district court before they are recorded at the county clerk's office. So must be in English. Very good, Gloria. Okay, number 88. What term identifies a broker who has written authority to represent both the buyer and the seller in a real estate transaction? A, facilitator, B, mediator, C, intermediary, or D, general agent? So identifies a broker who has written authority to represent both the buyer and the seller in a real estate transaction. So who can do that in the state of Texas? So these are Texas state questions. Ooh, did I skip? Oh, I skipped 88. We'll go back to 88. Sorry about that. Okay, nobody's taking a chance? Going once? Going twice? Lily, you are the boss. Hey, Magali. Oh my gosh, it's been such a long time. Thanks for watching, Magali, or for coming in to say hi. Hope everything is going good for you. I know, man. I'm now broadcasting onto my YouTube channel. I have 2 of those, one for students and one's for San Antonio, and Facebook pages and groups. Oh my gosh, I've learned so much since I moved from the Rio Grande Valley to San Antonio. And since I moved to also from Keller Williams to EXP. All right, anybody? Nobody? So the answer is C. Magali used to be a student of mine and passed when I was in McAllen, and I used to do live sessions in person. So the answer is an intermediary. A broker that represents both sides is an intermediary. So they are not talking to the actual client. However, they have a realtor representing the seller and a realtor representing the buyer. So each agent represents one person, right? In the state of Texas, we can only represent one person. The broker becomes the intermediary, kind of like a mediator. They cannot give advice, okay? They cannot recommend, they just mediate. Okay, they're in between and help them come to a conclusion or a decision if there are any issues. So they represent both clients, however, not directly. They represent them through their buying agent and their listing agent. So 89 was C. Okay. All right, going back to number 88, which I missed. Okay. The rules of Texas Real Estate Commission, which stands for what? TREC, TREC, prohibit a licensee from creating language and entering it in contract forms that define the legal rights and remedies of the parties. So which of the following would be acceptable language to enter in the special provisions? Section what? What section is special provisions? You see, did I leave the the contract on here. So what is special provisions? Who knows right off the bat? Type it down before I get there. There it is. Section 11 is special provisions. Who can write comments in there? And this is the new contract. It now includes leases in it. Okay. So special provisions is a paragraph of the Texas Real Estate Commission promulgated contract form used for what? A, this transaction is contingent upon the sale of the purchaser's present home. B, buyer reserves the right to terminate this contract for any reason within 8 days of the effective date. C, buyer will do a walkthrough inspection during the 4 hours immediately preceding closing. Or D, this contract is contingent upon satisfactory appraisal in the amount of the sale price. So anything that is already part of the contract doesn't get written into special provisions, right? So what would? So if they're going to do the sale of their home, there's an addendum for that is part of the contract, right? Buyer reserves the right to terminate for any reason. I'm sorry, not that one. A, transaction contingent on the sale of the purchaser's present home. Okay, so that one is the addendum for the buyer to sell their home. So that can't go in there because there's an addendum. And then there are reasons on why the buyer can terminate their contract, okay, that are stated within the contract itself. C says buyer will do a walkthrough. Do we have an addendum for that? And is it anywhere in the contract? You tell me. D, this contract is conditioned upon satisfactory appraisal in the amount of the sale. Well, the contract already specifies something like that, right? So what is 88? Oh, Gloria, so you got number 89 correct. C. Sorry, I didn't acknowledge you. So number 88 is, so which one could be written in special provisions? Okay, so section 11, and that is not for us to write, even though we do type it, we type it in there based on instructions from the seller or the buyer. They have to be factual statements that are not in any other document, okay, that says TREC rules prohibit licensee holder from adding factual statements or business details for which a contract addendum, lease, or other form has been promulgated by TREC for mandatory use. So if there aren't any other forms that specify that statement, then it can go into special provisions. But if there are other promulgated documents, then it cannot go in there. So nobody's taking the risk here. So 88 is C. The buyer will do a walkthrough inspection during the 4 hours immediately preceding closing. So that is the correct answer. That is not part of an addendum. In other states, yes, there is an addendum for an amendment for that, but not here in Texas. Okay, so now we're going to question number 90. Okay, any questions so far? So 88 was C. Okay, I jumped. I went from 87 to 89 and back to 88. Number 90. I don't see anybody asking questions. Okay. What state law requires leases for more than 1 year to be reduced to writing and to include a legal description of the property to be occupied by the tenant, right? We already talked about legal description, right? It's how a property is identified to be the legal actual property. So what law requires leases for more than 1 year to be reduced to writing? A, Truth in Lending Law. B, Harkness-Tennant Act. C, Statute of Frauds. Or D, Sherman and Clayton Acts. No one is taking a chance. This is time to do it. You're not being graded. Okay. Well, that's weird. You didn't type it. Why not? Huh. That's weird. Come on. There we go. I had the num block or something. Okay, 90C, Gloria says. Anybody else? Yes, the correct answer is 90C. Very good, Gloria. So Gloria and YouTube agent said 90C, but yes, I am YouTube agent, right? Ha, 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 ha. Oh, heck. Curtis also said 90C. Very good, Curtis. Doing good. So how come, oh, Gloria is on YouTube. Okay. That's why we don't see her on Facebook. Okay, 91. Oh man, it's a long one. So, when you're looking at long questions, remember you have 1 minute that you want to spend per question. Don't spend more than 1 minute because you'll run out of time. Okay, so, look at what are the key words within the question to find out what they're looking for. A lot of it can be just jargon. So salesperson Judy Jones is employed by A to Z Realty, Inc. Judy learns that A to Z's broker of record missed her licensee renewal date. Okay? When Judy questions the broker about this, the broker laughs and says, man, don't worry. There is always a grace period to renew. Really? Is there? Judge Judy. Judge Judy on TV. I don't watch her, but I have. Judy knows that this is not true, but decides not to say any more about it. Judy's conduct is what? Can she keep doing business or not? A, acceptable because she was following the advice of her broker. B, acceptable because the license at issue is not her own. C, unacceptable because upon expiration of her sponsoring broker's license, Judy's salesperson license is inactive. And D, unacceptable because Judy, as a real estate licensee, must conduct an independent investigation of any disputed fact. Really? So what happens when your broker's license goes inactive? They don't renew it. Or yours. What happens to our license? God, if I don't look at the little camera right in front of me, it's like I'm looking away. It's funny. I see myself looking to the right. Okay, Curtis says C. How about you, Gloria? All right, the answer is C. It is unacceptable because as soon as the license of the broker expires, Judy's salesperson license goes inactive. So Judy's got to move immediately over to eXp Realty, right? That happened to one of my sponsor several levels above. His broker's license went inactive. and a partner and EXP had contacted him and he wasn't ready to move. He calls a few minutes later. He says, oh my gosh, I need to move to EXP. My broker's license just went inactive. So that's how we ended up moving to EXP, even though he had many. It's canceled. It goes inactive. Okay, you don't lose it. It just goes into inactive status. And then you move your license to another broker and it becomes active. Okay, so the answer is C. It's not really canceled, it's inactive. Okay, number 92. What must a broker do to comply with the Texas Real Estate License Act, known as Trello? Trello, T-R-E-L-A. Texas Real Estate License Act. Know those acronyms. So what must a broker do to comply with Trello when placing a sign on a property offering it for sale? A, have written authorization from the owner of the property before placing the sign. B, have an exclusive agency listing agreement from the owner before placing the sign. C, identify the broker as a licensed agent on the sign. Or D, both A and C. So remember, we have to disclose everything and there's got to be agreement, right? So what must broker do to comply with Trello when placing a sign on a property offering it for sale? Let's see. Oh, Gloria, remember to write the question number, because then when I go back, I may not know which question you're responding to. So number 92 is going once, going twice, on. It is both A and C. So have written authorization from the owner of the property before placing the sign. And so that's a listing agreement, right? So well, not necessarily. Identify the broker as a licensed agent on a sign. It could be a for sale by owner, right? But you have written authorization from them. You may not be selling your property, but you want to promote it. And the owner is willing to let you do that. And it has to have the broker as a licensed agent on the sign. So 92D, A and C. You have written permission and identify the broker as a licensed agent. So the answer was 92D. Okay, number 93. Do y'all get that? It says, what must, so keyword is must, a broker do to comply with Trello when placing a sign on a property offering it for sale? It doesn't say they're representing the seller. It just says placing a sign on a property offering it for sale. Okay, they don't have to have an exclusive agency listing agreement before placing a sign on the property. That's only if you're going to list it and represent the owner. However, if the owner is willing to let you put a sign on the property, have something in writing that says they approved it. All right, number 93. If the effective date on the contract was June 26, 2005. Okay, remember this is an old an old book that was done back in 2006. However, very, very good questions still on there. Some are outdated. If the effective date on a contract was June 26, 2005, and it granted the buyer an option period of 8 days, option period of 8 days. So when does day one start? On what date at midnight did the option period end? In today's world, it ends at 5 p.m., not midnight. In the past, it used to be up to midnight. But how many businesses are open up to midnight? We might be awake. The lenders might be awake. but the normal businesses are not. That's right. You can't take something to the title company. You can't take something to the bank. They're closed. So they changed it to be 5 o'clock that afternoon. Okay, so you start counting from June. Now you need to know which months, highest seal, which months have 30 days, which ones have 31, and which ones could have 26 or 28, right? Leap year. Or is it 27, 28? Okay, so your knuckles on your hand have 31 days. January, the middle has either 30 and then or 28, right? So January, February, March, April, May, June. So June has 30 days, right? Because it's in the middle of the knuckle. All right. And then when you hit July on the little one, then you get August, September, November. Okay. So that's how you determine which months have 31 days and which ones have 30. So start at June 26th. So the 24 hours later is considered day one. So 26, you starts the clock, but 24 hours later is created day one. Even if you signed at 10 p.m., next day at 5 is considered day one. So 27, 28, 29, 30, right? Because it has 30 days. So that's 27, 28, 29, 30. That's 4 days, right? And it was 8 days. So then July 1st, July 2nd, July 3rd, July 4th. So that makes 27, 28, 29, 30. 1, 2, 3, 4. How many is that? 8, right? So at midnight, no longer, it's at 5 p.m. The option period ends. Okay? So 93 is A, 4th of July. Did y'all follow that? Because June has 31 days. So you don't count June 26. You start with the 27, 28, 29, 30. So that's the end of June. And then July 1st, 2nd, 3rd, 4th. That's 8 days at 5 p.m. So the answer is 93A. Very good, Curtis. All right, number 92. Oops. Sorry, number 94. Where am I? I'm thinking backwards. Okay. Been a long day. May a broker decide to offer cooperation with other brokers through sub-agency when placing a listing in the multiple listing service, MLS, right? Know your acronyms, of the local realtor association? A, yes, always. Is the option date mean 7 days? So how the 4th of July? Because the option period, a seal can be whatever number of days is agreed upon by the seller and the buyer. And here it said they had an option period of 8 days. So 7, the option period can be 1 day, 2, 3, 4, 5, 6, 7, 8, 9, 10, 15, 20. The option period is a number of days that the seller and the buyer agree will be their option period. So 8 days, which shows here, okay? 8 days, okay, from June 26 would be July 4th. That would be 8 days. It's not necessarily 7 days, a seal. It's whatever buyer and seller agrees to. And here it said, seller granted the buyer an option period of 8 days. Okay, very good. Okay, so 94. May a broker decide to offer cooperation with other brokers through sub-agency when placing a listing in the multiple listing service? You're welcome. MLS of the local realtor association. So A, yes, always. So may a broker offer cooperation. So B, no, never. C, yes, but only when the broker feels that it is in the client's best interest. Broker feels? Is it a feeling business? Or D, yes, but only upon receiving written authorization from the client to do so. Okay, so you remember what a sub-agent is, right? Many of us don't do the sub-agent. Now you end up representing the buyer by having a buyer's representation agreement, because the sub-agent ends up becoming the representative of the seller if they don't have a representation agreement with the buyer. Okay? So like our office at eXp, they don't allow sub-agency. The buyer agent will have a written agreement with the buyer, okay, to represent them. So we don't pay fees on the MLS to sub-agents. Doesn't mean I agree with it. However, that's the way it is. So the first one says yes, always. Keyword always, watch out for those. Second one says no, never. Say never. Well, that's not quite true, right? And then it leaves us with C or D. C says broker feels that is best for his client. We don't go by feeling. We go by material facts. Okay? So that leaves us with D. Yes, but only upon receiving written authorization from the client to do so. That means that buyer agent is not going to represent the buyer. They actually represent the seller, but they're still going to get paid. So that's only if the seller agrees. So 94D, very good. Okay, 94D, very good. Okay, let's go to, we're going to end at 96 today. Let's finish this page, even though it's after 8. I started a little bit behind because I was out in New Braunfels. Actually, I was in a training class all day for KV Core, and then I went to New Braunfels to put up a sign and lockbox and have pictures taken. Number 95. Which of the following would be considered part of community property owned by a married couple that are legal residents of the state of Texas? Remember, Texas has community property, not tenancy by the entirety. That's in other states. So which of the following would be considered part of community property owned by the married couple as legal residents are of the state of Texas? A, two rent houses offered free and clear by the husband prior to marriage. B, the $200,000 settlement that the wife received from her employer's insurance company for an injury sustained last year at work. C, the interest income from the certificates of deposit owned by the wife and purchased with the proceeds of her personal injury settlement. And D, a $500,000 inheritance received by the husband from the estate of his grandmother. So you have to think about what types of things are allowed, okay? Or insurance claims, okay? Physical injury insurance claims allowed, or inheritance allowed. You know, which ones are and which ones aren't. Properties bought prior to marriage, are they? Well, it depends, okay, on the income. That's number 95. Okay, so what is 95? Which ones are? Anybody? I kind of like this. We're on Facebook, we're on YouTube. We're on my personal page on Facebook, and then we're on our private group on YouTube. And on, we're on YouTube AgentPrep. We're on my personal Facebook page and on the AgentPrep Facebook group. I couldn't change the Facebook group to public anymore. Facebook won't let me. So I want the general public to watch it, because who knows, they might one day decide to become realtors and realize, wow, being a realtor can be an interesting career and a worthy one. Okay, nobody's taking a risk on that. So the answer is 95C. So any interest income from certificates of deposit. So it's any income that's coming in right now, at today's date, okay, whether they were purchased prior or with other proceeds. It's the money they're earning while they're married. That's earned income, earned interest, and that is taxable for both. So interest income from certificates of deposit, known as CDs, owned by the wife and purchased with the proceeds of her personal injury settlement. So it's okay if she used personal injury settlement. The CDs are her. However, any interest earned during that period belong to both. The CD value itself, no, because it was purchased with the injury settlement. However, the interest is, okay? Because if they're filing together, that'll be covered as earned interest. Okay, last question for tonight, Wednesday, June 23rd. Oh my gosh, June's almost over. Half of the year is almost over. 96. So get your questions answered, learn the material, learn the vocabulary so you pass your exams this year. Which of the following is not an addendum promulgated by the Texas Real Estate Commission, known as TREC? A, addendum for sale of other property by buyer. We did that in a prior question. B, seller's temporary lease. C, addendum for seller's disclosures of information on lead-based paint and lead-based paint hazards. And D, release of liability on assumption of FHA, VA, or conventional loan, restoration of settlement, of seller settlement, release of liability on assumption of FHA, VA, or conventional loan, restoration of settlements, entitlement for VA guaranteed loan. Okay, so which one is not a promulgated Texas Real Estate Commission document, an addendum? Okay, a seal says C. So remember, some documents are federal, so they're not part of TREC. The ones by TREC, right, are created by the board of 13 members, right? 6 attorneys, 6 brokers, and 1 civilian. Anybody else? Nobody else? Curtis says C. Si, oui, monsieur. Tyler Perry's movie. 96, oh yeah, 96C, you're right. Yes, the answer is 96C, right? The lead-based paint is a federal document. So 96C. Very good for participating, all of you. All right, so that ends today's class for review, prepare for your Texas real estate license exam. And it can be in other states because the national is covered in all states, all 50 states. However, the state section on here pertains to Texas. All of this 2 hours is recorded, and it'll be on the YouTube channel, the YouTube AgentPrep, okay, that you see here, YouTube AgentPrep, and also on the Facebook AgentPrep website, Facebook group. That's the private group that you're all a member of, if you're in that group. And those of you that are on YouTube, you may not be in the group. However, you can join the group and see prior videos. We have now about 5 or 6 videos on YouTube of the 2 hour plus long that we do Wednesday nights and Saturday. This Saturday, I'll be in South Texas putting another property on the market, a listing, a repeat client, okay, past clients. So that's awesome. I've got 3 listings and I'm working on 22 more that I've got to get by the end of September 13. I made a commitment to do 25 listings in 3 months because I've done it before and I'm going to do it again. I'm going to affirm I have 25 sellers. I have 25 listings. Okay, 25 sellers that committed to list with me, moi, and get those sold and refer them to some of my realtors at EXP to represent the buyers. Okay, any questions? So remember this material, the Texas Real Estate Sales Exam, Texas Real Estate Sales Exam, license sales exam, real estate license sales exam, 4th edition. It's on Google, okay? But it's actually also on our YouTube, on our Facebook group. It's an excellent source. Let me put a link of it on here. I should have a quick link. And sales. You can go to the group and download it. Okay, this is where you're going to download it in our group. Okay, so in our group, you go into more, under files. And I added a lot of other documents on here that you can use to review and study. I got them from other sources, other Facebook groups, acronyms. So it's this one here, Texas Real Estate Sales Exam Guide. All right, and so what it does, all right, you have to click it twice, once to download it. Let me see if I can grab a link to it. No, because it's a PDF file. Let's see. I shared it in the group, okay? And I don't think let me see, can I copy this? Copy, let me see if it'll let me paste it. I'm not sure if that'll work. No, it won't paste it on there. It has to be on so the way I found it, okay, Texas Real Estate License Exam, 4th edition. You can buy it, but I wouldn't buy it when it's free on here. But you have to find the correct place where you can easily download it as a PDF. It used to have it. Now they make it a little bit harder. You have to go to somebody's Facebook group or somebody's page. Like here, Amazon sells it. This one might have it as a PDF. Okay, yeah, so this one here says preview PDF. Okay, and there it is. And then you can print it, download it. Okay, you can click download and it'll download it. And that'll be the actual document. So you can get it from Google. Okay, it's there, it's free, or you can get it on our Facebook group, just as I showed you. More, files, scroll all the way to the bottom. Okay, and it'll be there. Texas Real Estate Sales Exam Guide. All right, so next class will be next week on Wednesday. No, there's no class on Saturday, Curtis, because I have to make a one-day trip. I'm going to try to do it in 24 hours. Just go down there, put a sign, lockbox, view the property, take my own pictures, and have a professional photographer and get it on the market next week. That'll be the third property that goes live for me. Okay. Remember to keep studying. Affirm, I passed, I passed, I passed. Study every day. Practice your vocabulary, your national questions, state questions. If there's something that you don't understand, go and review the summary of that section. Okay. Study acronyms, vocabulary, additional questions from other exams so that you are well prepared. All right, y'all. Catch you later. Until next time. Good night.